As legal practitioners, we felt duty-bound to rise and do something about this catastrophe that is engulfing our society. We do this not for our own sake, but for the sake of the vulnerable whose salvation lies in us who chose to be their voice. We are here to speak for them and highlight the failure of a system meant to serve them and in the process threaten the rule of law. We are in a crisis when an organ of state undermines court orders. We are in a crisis when administration gets to be normalized. We have, as a profession, thought it appropriate to call upon the relevant ministers, the board and the management of RAF to do something about it. We have proposed solutions in the memorandum that we sent to them, and all what we ask is an opportunity to be listened to. This is not about us, but the country and its people. Together, we can fix it. This afternoon, my colleagues who are seated with me here are going to offer the proposed solutions and highlight the nature of the problem that we are having. On my left, we've got, you can come and introduce yourself now.
Good morning, ladies and gentlemen. Good afternoon, good day, ladies and gentlemen, and good day to the listeners at home. I'm Lily Malatsi Tefu. I'm the Deputy President of South African Human Lawyers Association, and then we are here as the collective, as he has indicated, together with the doctor's profession or the medical profession. And we are here for the same crisis and to see as to how can we get our heads together to ensure that we resolve and we come to a solution to the crisis that is facing all of us. Thank you.
Hello, good afternoon, everybody. I'm Justin Erasmus. I'm the chairperson of the Personal Injury Plaintiff Lawyers Association. And if I could just start off by saying how happy I am to have Mr. Letswalo here. He's somebody we've been wanting to talk to for years, and I hope that this is the first step in a long process of engagement that we would like to have. We don't have answers. I can't say I'm going to talk to you about answers. I'm going to talk to you about a few problems, but hopefully those answers could be found if we engage going forward. The profession generally, plaintiffs, claimants, and the Road Accident Fund. So something that needs to happen together, all of us, so we can take the steps forward to solve the problems as we see them. Thank you.
Good afternoon, ladies and gentlemen. My name is Herman Edling. I'm a neurosurgeon and medical legal practitioner. I'm here speaking on behalf of SAMLA, the South African Medico Legal Association. We are an association of healthcare practitioners who are engaged in the assessment and reporting on people who've been injured, who are permanently disabled, and we provide reports to courts and we provide medical information to the legal system in order to appropriately and justly compensate people who are permanently damaged or disabled. Why are we here? Because we work in the industry and we see these people, we see of people who've been permanently damaged in road accidents, and we also see the consequential suffering on their families, especially when the injured person is a breadwinner. So every time we consult with anybody, we see tragedy for that person and the family of that person. We are deeply concerned at problems in the system, and when I say problems in the system, I refer to various judgments, and I refer to the findings of the chairperson of SCOPA, the Standing Committee on what is SCOPA? Standing Public Accounts. Thank you. We are deeply concerned about that. What we see out of our own practical experience is the very long time, years and years and years, that it takes before claims are settled or adjudicated, and we keep on seeing obstacles in the way of effective and timely settlement of claims. So that is why we are here, to support the aims of the legal profession, and we, in the memorandum that has been provided by the legal profession, towards the end, the second and third last pages, there are proposed solutions. As SAMLA, we support the principles of each of those solutions. Thank you very much.
Okay, fantastic. So the way I understand it is that we are going to work on a questions basis, and then get some responses from our representatives here. Would you like to make a submission, sir?
Thank you very much. My name is Collins Lizwalo. I'm the CEO of the Road Accident Fund. I just wanted to introduce myself, but also say a few words. I have read with concern to all South Africans, and I think my colleagues of the RAF that are here, very disappointed and indeed perplexed by the complaint from the joint legal profession. Of course, we will be here today to dispel the myths and what we term a charade that can never be based on hard facts. Of course, facts are by themselves very stubborn. I think the real quest of this memoranda was for a perfect storm, and this is evidenced by the ending board term. The board of the RAF term is coming to an end. The dispute with the AGSA that is known to everybody else, the SCOPA hearing, and of course the visit by SCOPA, and a cabinet reshuffle that has seen Ms. Nchigo Chukunga becoming the new minister, and the so-called non-responsive road accident fund that has never met with no one in the past years. I think this cannot be further from the truth, and we'll prove it as we go forward. I think the most interesting aspect is to try and paint a picture that the wheels of the road accident fund came off when the new administration came. And that can't be further from the truth. Those who know will know that since 1981, he grabbed
If not, I'm going to open the floor to questions, and then we'll take them round for round. Yes. Okay, fantastic. You're more than welcome, yes.
Afternoon all. My name is Tian Yeber. I'm the current chair of the Gauteng Attorneys Association as well as the Pretoria Attorneys Association. We are voluntary associations comprising of the Johannesburg Attorneys Association and the West Rand Legal Practitioners Association as well. We are voluntary associations who our main purpose is to do things that benefit attorneys. We work on ground level. We are there to ensure that attorneys can practice in a safe environment. And we meet with stakeholders all over the Republic, ranging from the LSSA to the courts, Master of the High Court, etc. We were also instrumental with the writing of this memorandum, and I would like to thank our members who made the effort. This is historical to getting all of these associations together. This is the first time. The Law Society of South Africa, BLA, NADEL, SOLA, PIPLA, PAA, GAA. This is the first time this has happened. So this shows the extent of the crisis that our members are experiencing in this regard. That's what's bringing us all together. And that's basically just the introduction as to where we fit in, and I will hand over to the MC. Thank you. I wish to the way I would like to respond is basically there's a saying that the attorneys are taking 10.4 billion away from the claimants. Now, first of all, the MC had mentioned we should speak in a clear language so that readers and viewers can understand what we are saying, what we are doing. Now, we need to understand, what is an attorney? An attorney is someone who has studied for a minimum of 4 years. After that 4 years, this person does his or her practical vocational training for 1 to 2 years. He does this, or she does this, under the pupillage or the training of a mostly senior attorney, making sure this person is trained properly. Then there are 4 board exams which are to be written, and these board exams deal with the subjects of inter alia court procedure. Amongst court procedure, you have to deal with RAF matters, ethics, accounting. You can only enter into this agreement if the Legal Practice Council has found you fit and proper. After you've done this, you bring an application to court. The Legal Practice Council has to vet this contract. After this contract has been vetted, you bring an application to High Court, where 2 judges preside over your application. So to become an attorney, you have to jump through a lot of hurdles. You are a professional. You are seen in the same light as auditors, medical doctors, etc. It's a profession. It's something a goal-orientated person will do. And what we attorneys do, we act on behalf of people from the street. We are acting on people who need help. We are people who are supposed to find solutions. Now, saying we just after the money, that's not true. We are doing this on behalf of people who need our help. There's a Road Accident Fund Act, which is clear. There's a Contingency Fee Agreement Act, which is clear. We are highly regulated. We're regulated by the Legal Practice Council, whose main purpose is the public. So if we overstep our boundaries by, for example, taking money or doing something we're not supposed to do, there is a Legal Practice Council. We'll make sure we stay on our way. Furthermore, accounts are taxed at the end of the day. So what we're getting is in terms of regulations, in terms of rules of court, in terms of the Act. We're not taking more than we're entitled to. Yes, there are bad apples. Unfortunately, that's what gets the most attention in the media, is the bad apples. An attorney stealing millions of rands from innocents, which is, it does happen. But for every one bad attorney, there are 100 good attorneys, or thousands of good attorneys, acting on behalf of tens of thousands of victims who need our help. We are helping. That is not being taken into consideration. We are not the bad guys here. We are here, we wrote this, in this document we set out the challenges that we are experiencing, and we're also giving a probable solution. We're asking, we're reaching out, we're giving a hand out and say, let's make this workable. Let's not fight. Let's come to some kind of agreement, some kind of solution. That's what we are here for today. And that's in a nutshell. I'm replying mostly to the accusation that we are taking money. I'm certain my colleagues here will also address on certain of the other aspects that's been raised by Mr. Letsoalo. That's me for now. Thank you.
I'm going to provide an opportunity to some of the other representatives of the legal organizations here if they'd like to add anything from their organization. Mr. Letsoalo, if you would like to provide a response, you're more than welcome to.
No. Let's just deal with this animal in the room. This thing that practitioners are taking money, it's insulting. It's insulting, to say the least. And for quite some time, members of the legal plant that this language that we requested for a meeting from the Minister of, we requested for a meeting from the Minister of Justice, the Minister of Transport, the CEO, the board, and none of them whatsoever cared to respond. And what is it that we are faced with? We are faced with a government that is non-responsive. Judges are complaining about the court roll that is fully clogged. Default judgments that are being taken. And every default judgment goes with a cost order. And when a court has ordered that costs be paid, it can never be correct to say that lawyers are taking money. Because a court properly constituted had determined that the claimant is entitled to the costs that he had incurred in prosecution of his or her claim. And why are matters taken to court when they should not be taken to court? Matters are taken to court because the Road Accident Fund, which is entrusted with the responsibility of managing claims, it's failing in its duty. And what does the law say? The Road Accident Fund has got 120 days to investigate a claim. If 120 days passes, the claimant has got a right to approach a court because at that stage, he or she is declaring a dispute. And once a dispute is declared, a court of law is entrusted with the responsibility to adjudicate on that dispute. And what does the court say? He who succeeds gets the cost. If the Road Accident Fund does its work, a bulk of cases would not see their way into the court. And if the management of the Road Accident Fund were to wake up one day and make sure that their system is fully functional, the Deputy Minister of Transport who said that we are causing sheriffs to go there, honestly does not know what she's talking about. Sheriffs go there because the Road Accident Fund is failing to honor court orders. And what happens when a court order is not honored? A sheriff goes, attaches, sell, and pay the claimant. Nothing illegal about it. Any person in the administration should know that. So we need to be very clear here that we are not after the Road Accident Fund's money. We are by our own profession entrusted with the responsibility to represent people who cannot represent themselves. We speak for them. We are the voice of the voiceless. We are the voice of those who cannot, who do not even understand. It takes a lot of money to prosecute a claim. And we've got medical practitioners who sacrifice a lot in their practices, their time, their resources. They prepare reports in the hope that when the claimant gets paid, they would be refunded. what happens? We are told a court order takes 180 days. It's made an order of court. 180 days comes and passes. Nothing happens. So this is not about individuals at the RAF, and that message must become very clear. It's about the system. The Deputy Minister of Transport, I'm singling her out because of the fact that she tried to shift the blame to the lawyers. And the Minister of Transport, the Minister of Justice as well, needs to be worried when his judges are unable to do other work because the Road Accident Fund has clocked the roll. 240 default judgment cases in a day in Johannesburg, in Pretoria, in Mpumalanga, Western Cape, everywhere in the world. Where is the RAF to defend itself and to assist the court in adjudicating all those matters? So we cannot be insulted in our presence that we are stealing money. We cannot be insulted in our presence, and the time has come for us to defend ourselves, at least when we are insulted. But the purpose of today's meeting was actually not to attack anyone, and we had no intention of attacking anyone. But when we get to be attacked continuously, we've got to defend ourselves, and we will do so ruthlessly.
Please just introduce yourself as well. Thank you.
Good afternoon, everyone. My name is Wendell Bloom. I'm the chairperson of the Johannesburg Attorneys Association, as well as the vice chair of the Gauteng Attorneys Association. I will not describe the association as Mr. Tian Ubera has done that aptly, and I join issue with him on that. And I'd like to say from my perspective that I do agree with my colleague with everything that he said here, together with Mr. Tian Ubera. I have the distinct advantage of having done work on behalf of claimants for a number of years, and then also being a representative of the Road Accident Fund itself for a number of years. And what is relevant about that particular scenario is that we had a situation, and gentlemen such as Mr. Justin Erasmus, Mr. Yusuf Wadi would remember, that there's been all manner of measures implemented, even with the assistance of the courts, to try and ensure that victims' matters are properly dealt with by the Road Accident Fund to begin with, and by the courts. I remember one particular instance in 2009, where the DJP at the time, Judge Phineas Majapelo, set down something like 150 matters on one day. And the reason was to try and deal on some level with a backlog. I was doing work on behalf of the Road Accident Fund, and why I mention that is I had close to 50 matters on the roll on one day. And some of you that know this incident or this period would know why it was done. And why am I referencing this? Is we are now in 2023, and we are just speaking of the same problem, just in a different format. And the problem is management at the Road Accident Fund. I agree completely with my colleague that this has nothing to do with, we are not here to discuss the legitimacy of court orders, sir. We can all agree that what a court order says is what it says. We can't then have a interrogation of what does that mean in terms of fees for the attorneys, because all of these things are regulated. There's a regulatory environment within which attorneys work. We have to identify the source of the wound. And the source of the wound is the management of the Road Accident Fund, which has, for decades, taken various forms of mismanagement. We have to identify that there is mismanagement of how claims are dealt with. I have personal experience of that mismanagement, I'm sorry to say, and I've been there having to deal with matters either for plaintiffs or against them, where a day before a matter you have to deal with 10 medical legal reports and provide executive summaries and all manner of things. it can be as shambolic as you can possibly imagine. Why am I highlighting that is that I don't see any progress from that situation to where we are today. And if we are then wanting to have a conversation about attorneys, then we are missing the boat. This is not a discussion about the value of attorneys' cost. If you have a problem, Mr. Hubert is correct. There's organizations and there's structures that you can go and address this on with regards to fee structures. We've got to identify the wound. And the wound is, unfortunately, for decades upon decades, road accident fund management. Thank you.
Yes, so you're more than welcome.
Thank you so much. Let's start here first. I think the last speaker I agree with for decades and decades. And it's very interesting that we have tried over the last few days or 14 days or so, where we have been trying to find this memoranda that was written in decades. Because, I mean, there's a memoranda that comes here today. And I think South Africans must be cautious of organizations that misrepresent themselves as many while they are one. I mean, the LSSA captures a lot of other organizations that are here. Most of them are actually members of the LSSA. I think let's have it. DLA forms part of LSSA. NADEL forms part of LSSA. I suppose the Pretoria Association might just be part of LSSA. And as well the Gauteng Attorneys Association, which is also a conglomeration of Pretoria and Joburg. And therefore, it might well be that we are dealing with actually 3 organizations here that people think are 10. So it must be very clear there. Now, the interesting phenomenon is when people want to blame government for everything that happens, right? So when a minister comes and says the following, or a deputy minister says something, people say, well, we take offense on these things and all that. We are told that we are mismanaging an organization and we don't know what we are doing. And that may well never be an insult. Okay? I always say these are things, at times, maybe people lie, but I suspect they are confabulations where people are just having false memories about events. Because that's not true. And I'm going to refer South Africans to a judgment. I've quoted it extensively. I think it aptly captures the crisis at the Road Accident Fund, at least in 2015. And I think it also lists a lot of judgments that come from 2002 onwards. And I think it aptly captures it. And this issue of saying, well, it's not the legal fraternity that is a problem, it's the management of the Road Accident Fund that is a problem and all that. We would know that this fraternity has always been against what is called RAPS, the Road Accident Benefit Scheme. It is this fraternity that never had that. But there was a rationale of why they did not want RAPS. And I think it's something that one must read. Section 19C, Roman figure 1 of the Road Accident Fund, which was written, and it's a law, writes as follows. And people will say, well, why does this new management never? And they say it in their memoranda that we have actively been engaged in getting direct claims. That's not true. We stopped that when we arrived because we realized that, as it were, like any other legislation that comes, the lawyers had wrote themselves into this act and we couldn't do anything about it. Section 19 talks about the liability excluded in certain cases. The fund or an agent shall not be obliged to compensate any person in terms of Section 17 for any loss or damage. And it then says in C, if the claim concerned has not been instituted or prosecuted by the third party or on behalf of the third party by. Listen to this, an interesting phenomenon. I'm yet to find this other person, but any person entitled to practice as an attorney within the Republic. I think there was a speaker here telling us how you get to be an attorney, and there can't be any question about it. Someone must then ask this second person who this person is. You can't find them anywhere in South Africa. Any person who is in the service or who is in a representative of the state or government or provincial, territorial or local authority. Go anywhere, you're not going to find this person. So here's the reality. It is the lawyers that have the ability to do this and no one else, because the definition here does not say a RAF employee. And this is the problem, because people will say, well, the RAF must have settled claims within 120 days. But what they are not telling you is they enter empty claims into the road accident fund. Right? They give us claims that don't have anything to work on to make an offer. And they come and they say, well, you must actually make an offer. But there is a provision that they've been abusing, which is section 24.5 of the RAF Act memorandum. You are going to struggle very much to find it, and I challenge them to actually show you where. Section 24.4a says any form referred to in this section which is not completed in all its particulars shall not be acceptable as a claim under this Act. Now, I'm not a lawyer, and they make a beef about the fact that I'm not a lawyer. But they have not read this provision, because if they have read this provision, they would understand that what is expected in this. This is the law of dict. You must submit this claim with all its particulars. The particulars of claim must form part of Section 1. Object to the validity thereof. The claim shall be deemed to be valid in law in all respects. Now, in all law, because I don't have the documents, right? So they go to the extent of submitting a claim without an accident report. Now, where do you get the nexus between the injuries and the accident and the claim? You need that for at least you to be able to do that. So they wouldn't want to come and profess the fact that that became a summons generation machine in 60 days. Once 60 days policy is valid in all respects in law, then in 120 days they are going to simply issue summons. And when they issue those summons, I must defend them. What am I defending? Nothing. I know nothing about this thing. It's empty. So they don't want to deal with this matter because they then say, no, the minimum requirements. Who refuses the minimum requirements? Because if it's in the interest of the claimant, you will bring all these documents. By the way, information, they just drip feed us. They bring it empty. They know it's going to be valid. It was by the retired Judge Beddersman, and it is scathing on all of us, by the way. The road accident fund at the time concerned. And one of the most interesting phenomena is in 2013-14, our predecessors released a strategy that wanted to settle claims in 1,400 days. We never saw a memorandum. We never saw a memorandum from this fraternity. But now we are saying we are doing it in 133 of this judgment says, when confronted with this entirely unwarranted course of conduct, Mr. De Vries candidly admitted, as stated above, that the only reason for presenting the charade of intending to call expert witnesses was to ensure that their fees and the costs associated with producing their reports could be included in the cost order that would be sought against the fund. Now, we are told here that it's not about the money. If no notice were given and no reports were filed, the plaintiff attorneys would have to foot the bill of the expert witnesses. These facts need only to be recorded to establish the lack of bona fides and probity on the part of the legal representative. Listen to this. This is the judge. The only object of this exercise was to plunder the resources of the allegedly insolvent fund. This is what the judge says. Then he says, the next paragraph, he said, the legal representatives were complicit in operating this scam, as were those of the plaintiff. They readily conceded that they would never have agreed to pay the plaintiff costs on high court scale, but proffered no explanation what motivated them to do so. They did not even attempt to explain why they agreed to burden the fund with costs unnecessarily medical legal reports. The explanation is obvious. If the plaintiff lawyers were entitled to fees calculated at high court scale, the taxi master would be hard-pressed to disallow their fees pegged on the same level. Now, I don't want to deal with this thing on the lawyers alone, right? I'm telling you there's no memorandum, but I want to read the part that deals with the RAF. It says, I think it's paragraph 38. It says that nothing has changed in the fund's approach to dealing with claims submitted to it by victims injured in motor vehicle accidents since it was confronted with the common cause facts recorded in the judgment of the full court. Instead of promptly and properly investigating the merits of these claims, the fund usually does nothing until the very last moments. This is in 2015. There is nothing is written by the legal fraternity or the profession. They don't come together. There is a problem at the Road Accident Fund. 39 says the fund's approach to litigation constitutes a serious dereliction of duties to road accident victims, the public, and the courts. The fund is an organ of state. They do nothing still. These representatives, at the time, management was not insulted and told that they are mismanaging anything, right? But here is the part. In this, there are judgments that span from 2002 in the judgment. I think they are under paragraph 39. They are listed in Daniels and others versus the RAF and others. But I want to read you this part of this Daniels and others under paragraph 23 of that judgment. It says, a depressing feature of all the aforementioned judgment is that they instance examples of cases in which the fund must have incurred substantial legal expenses in taking to trial or on an appeal claims which it had no basis to responsibly contest. This is what we expected, that when people just use this summons generation machine that I'm talking about to flood the courts, we must follow with defense. And of course, what happens is that once there is a defense, even if it's not responsibly contested, we must pay for those costs. I don't want to belabor the point, but I think the part that I'm making is that we had a dysfunctional RAF. Nothing was being done by this very same fraternity and everyone else. We had a management that decided they are going to settle matters in 1,400 days. There was no uproar. Of course, lawyers were going to make money in 1,400 days. They then complained that, no, you are saying we must bring all these documents before. But they've got 3 years. They have 3 years to put in a claim. They want to enter it there. They call it, I don't know, substantial compliance or whatever they want to go. They say it in the memo, they don't want to have full compliance. They tell us that. And they tell us that this is in the interest of the claimant. Where? Now, here is the part. They are going to claim that, no, the RAF is inefficient and all those things. We were better. Here is the judgment. Here is an interesting thing about this judgment, by the way. I think this judgment, when it says the order, when it gets to the order, it says, a copy of this judgment to be sent to the Law Society of the Northern Provinces and the Pretoria Society of Advocates for their consideration of ethical implications of legal representative conduct in these proceedings. What did they do? When they are given this, what did they do? Now, it's an interesting thing where you want to blame a state for this. Let me also deal with the issue around illegal immigrants. Right? I don't know if people read the Immigration Act. There is a part of aiding and abetting an illegal immigrant. I don't know if they read it. And here's the question they must answer. Because these illegal immigrants also don't have bank accounts. When they receive this money, where do they pay it? Because the guys don't have bank accounts. So they are saying we must aid and abet. And there is a provision in that Immigration Act that expects an organ of state to act in certain ways. We must know who we are dealing with and their status in the country. And when we don't have that, we must report it. It's there in the Act. So this is the part where people are going to use sound and fury. The taps are closing at the Road Accident Fund. People say, where we sit, this thing is collapsing. And I'm saying, what is the objective test? When we arrived, the RAF was performing at 56% of its targets. We increased it to 78. We increased it to 84. And may I add, when we finish the audit this year, you'll see that it's above 90%. This is an organization that is claimed to be collapsing, a calamity, unprecedented. It's wrong. And I think when people write documents and they say, well, we wrote this thing in the view, they attack first, and then they say, we want to come around the table. We met with the BLA in December last year. We agreed with them that quarterly we must meet. We are still waiting. Yeah. So we are still waiting for that, right? The SAMLA, we meet with them, we talk to them. There's no problem. I'm not understanding why people want to write things and then cast aspersions about us and all that. Lastly, there is no law school that teaches asset and liability management. There is no law school that does that. This is a fund. The financial professionals of this country, which I'm part of, understand asset and liabilities management. It is unfair to sit here and prefer that, no, you guys go to school for a long time. We also go to school for a long time. And we also are professionals in our own right to do the right things. And it is unfair to now elevate one profession above all others. Here is the part. Our doors are open for people that are willing to discuss. It must be about the claimant. If it's about the money, there is no door that is going to keep open. But if it's about the claimant, let's all discuss. Thank you so much.
Okay, we have a response from your side.
I could just say it's disappointing how the tone of the dialogue here has moved from constructive between the Road Accident Fund and the various bodies. I'm going to give made a bleak reference to now, which is a new RAF 1 claim form, which was promulgated in July last year. The RAF 1 claim form from last year has a man wants that document. Yes, they want to settle claims. They want as much information as they have as early as what they can in the process so they can make you an offer. People, we represent many people who are the poorest of the poor. Those are your normal Road Accident Fund claimant. It's a very poor person. It's the hawker next to the road that got hit by a taxi who doesn't have the records. It's not always easy to put those documents in. It's impossible for the claimant on the street to do so. It's difficult enough for an attorney with resources to do so. So it's when attorneys say, but the RAF 1 claim form is unreasonable, yes, it is unreasonable because it's exclusionary in nature. It excludes people because they can't comply with it. Road Accident Fund is also reasonable because they say, we need this information to settle the claim. So what do we need? We need to talk. We need a via media between these two things. It doesn't help that we stand in this room and confront each other and say, yes, in 2001 you did this and you did that. The claim form is an extremely clear example of how both, I say sides, I use that term reluctantly in this room, can see a problem completely differently. Both make valid points, and we really need to discuss this without acrimony and without any animus between the parties, and to try and find a solution, because that was the purpose of the memorandum that was written, was to try and initiate a dialogue to identify problems and to try. Claims are being undercounted, which is very bad for everybody. The Road Accident Fund can't plan going forward. Attorneys can't get their matters into court. We need to talk to each other. We need to find solutions to this type of problem, and we need to stop bickering. Sorry, that if I'm a little bit heated, I do apologize, but I feel quite strongly about this. We cannot carry on how we're carrying on. There are problems, we need to find solutions together. Thank you.
Just to clear the issue of the issue of the claims that have been entered, the empty claims, or rather to call them shell claims, that our colleague Mr. Take an oath whereby we are saying will be bound by the rule of law, and we are indeed bound by the rule of law. And when we are, submitting the claims on behalf of the claimants, what is applicable here is the rule of law. The Road Accident Fund is regulated by the RAF Act. Once you lodge a claim that is empty, that does not have aspect like that, it can be processed by the RAF, because the Act says it's non-compliant. As a result, there is no claim. So there is just no way that an attorney who has taken an oath would take that particular object and take it to court when they have not complied with the Act. Another aspect that I also want to indicate to the people or to the listeners at home, non-compliant. There is just no way. The judge will rather take that matter and chuck it out because it's not compliant at all. And as I was going through my investigation, Mr. Litswalo, I noticed that on that issue where you have decided, it was decided by the RAF claimant to do the direct claims to the RAF, to the Road Accident Fund. Aggressive campaigns percent, and then there were about 8% fewer successful claims than the previous year. What does this tell you? It says that there were rejections from the Road Accident Fund. And where were these rejections coming from? These rejections are coming from the fact that an illiterate claimant is going to the not that is not filled in and not signed. It will be the accident report that is not attached. As such, it is making these claims to be non-compliant. Then the claims handlers will do what? They will they just reject those. And the poor, illiterate men on the street, or men at home, or men and women at home do not know what to do. So that is basically what is happening. It is not the attorneys. It is because of the fact that we're dealing with poorer of the poorest who do not know how to read. Can be complicated. Thank you.
Okay, yes, sir, and then from you, and then over there, and then over there. Great, I'll make a list.
Thank you very much. Mr. Letswalo, I just want to acknowledge something that you said. You said very little about SAMLA, but I want to confirm that SAMLA participated collaboratively with the Road Accident Fund in doing a mediation pilot project. And I congratulate you, Mr. Letswalo, for your foresight in doing that. And that was a very successful engaging further, now that that mediation pilot project has been completed, about the further and more widespread implementation of mediation. SAMLA also has considerable expertise in relevant issues, such as the training and professionalism of medico-legal practitioners, the writing of medico-legal reports, the effective and cost-effective assessment of claims by medical experts. SAMLA has that, and SAMLA offers that willingly to the Road Accident Fund, and we really look forward
each other. We're here to find a proposal so we can assist our clients, to assist the victims. We need to move away from trying to fling accusations at each other. We can quote all we want from rules and from acts. Amongst attorneys, that is not a fight you will win. Let's rather focus on getting to some kind of sensible a proposal. We did give a proposal. Let's work forwards. Let's not hamper about the past. Yes, we do take note of. Actually, I should say it's not fair to refer to single issues which have been taken in the past. Like I said, there are bad apples, but we are moving forwards. On the Pretoria Attorneys Association side, we've put on 3 forms on our website on ppv.co.za, which will hopefully enable us as well as the Road Accident Fund going forwards. We've put on forms where we've asked claimants to put their stories regarding dealing with the RAF, settlement ready matters, as well as new claims rejected. Hopefully this will assist us and the RAF going forwards. That's what we need to deal with. We need to go forwards. Thank you.
Okay, so in the third row over there, we had a question, and then coming to the gentleman on this side.
Thank you. My name is Yusuf Wadi. I'm from the Johannesburg Attorneys Association. I've also had the privilege of representing both the Road Accident Fund and claimants during my long career. At this moment in time, I just wanted to address 2 specific aspects. By the attorneys, they are currently lambasting. So it is essential to note that attorneys act on behalf of their clients, and in those circumstances, we're acting on behalf of the Road Accident Fund. And you will note that we were talking about objections and compliance issues. It's all well and good that we talk about what actually translate into. It translates into more litigation, not less litigation. It does not discourage the Road Accident Fund victim in any particular way, because their attorneys will not give up. They will fight for the rights entitled to by law, even if the RAF are indeed rejecting these particular claims. Now, this matter is subject. I want to say on behalf of the victims, all victims of road accidents are the vulnerable in our society. And it's important to note, an injured person who cannot earn a living has many dependents as their breadwinners. Their families are severely affected if they're called upon the Road Accident Fund and the various other stakeholders to a meeting. The victims at the end of the day have to go through a costly exercise just to get the Road Accident Fund to comply with their statutory duty. This is unfair on the victim of road accidents, and it's very crucial for us at this juncture to put the victim first. While we're discussing today, this is an open letter. Mr. Letswalo, we are inviting you as the legal profession to join us in a meeting with the most important and crucial element being the victim. How do we find a common solution to a medical problem that this particular victim has sustained? I've heard a lot of talk about compliance issues, about the law, about litigation. The loser at the end of the day is the fiscus. The more combative we are, the more costs are going to be incurred. And yes, the legal profession are entitled to charge for their time worked. But the cause of that is as a consequence of the Road Accident Fund not finding amicable solutions to solve claims. Lawyers would love to accept offers from the Road Accident Fund if they are indeed fair and reasonable. It costs a lot of money to represent a litigant, and it's important to note that what we are requesting and what you have stated is just 2 sides of the same coin. We are dealing with the victim. There must be a more important way that we can sit down and find a solution as opposed to mudslinging between attorneys and the Road Accident Fund. We are looking for common solutions. Most of us represent organizations that sit on the various court committees. Working with the judiciary, most of us in this room have been placed on a subcommittee where we have requested from you to have this particular joint meeting, not for the purposes of finding a final solution, but to discuss case flow management. The invitation is indeed open on behalf of all of us, and we are looking to find reasonable and equitable solutions between the organization, the courts, and the infrastructure. This must be taken into account, and we call upon you to accept this invitation together.
Thank you, ma'am. My name is Desmond Mpatlele, and I work within an organization that assists a lot of these road accident fund victims. And from the CEO's submissions and responses, I also just have responses and possibly questions as well from the responses of the CEO. Well, Mr. Erasmus, I would believe, firstly, I think, for us to reach any solution in this matter, the CEO ought to have given us a response to the letter that you have sent, categorically dealing with the issues that is stated therein. Those things are not false, they're happening daily in the courts and in the administration of the fund. So that can give us an indication as what we will achieve in this sitting by not having that response from the CEO. Now, what the fund has done is it has introduced the new Regulation 7, which we've spoken about it, and the CEO has spoken about it in many interviews. And he mentions Section 24.5, which may claim. Now, his interpretation is very wrong. We know it's tried, even if you lodge a claim and it's fraudulent, that when it gets to a court and it's noticed that there's no injury which happened from a collision, that no award can come from such a claim. Now, Section 24.5 deals with substantial things of process like accident reports, hospital records, Section 19 F affidavit, which must come with the claim. And if they do not come with the claim, they must lodge an objection so that you could give them whatever documents they need to proceed in assessing the claim. Now, that's at least under the old regulation. Now, under the new regulation, the fund expects you to lodge your claim up until the actuarial report, in essence. Because they say substantiate what your loss for earnings is. And it's only ultimately the report of the actuary that can substantiate that. Now, what that means is that these claimants must have on average 100,000, which is what would cost to quantify these claims before they can lodge a claim. Now, what that does is precludes the claimants from lodging and bringing the claim. It actually stops them from accessing the social security mechanism. And it's quite right, this is a social security mechanism. And if anything, the fund has been successful in stopping people from accessing this mechanism through this regulation, which, as you said, sir, it's lispendence, but we could even take it as far as it being unconstitutional, because this is a social security mechanism. You cannot have such hurdles before you could have the assistance of the fund. Now, he also ignores that the fund has in itself a responsibility to assess the extent of these claims. So, if a claim comes in, has got all substantial documents, hospital record, accident report, 19F affidavit, they can take that client or claimant to a medical expert of their own choosing, who will come and give them an objective assessment of what the claim is. So, and also on the late settlement of matters by attorneys, and that this is actually a problem created by attorneys. its genesis is in the administration of the fund. At the time when there was a panel attorney, I was also employed in such a panel attorney, and we would receive instructions from the fund at the doorstep at court, and we would settle the matters on the doorstep of court because that's when we received those instructions. Now today we have the state attorneys and its drips and draps, but that still continues. They go to our courts, they tell the judges they don't have any instructions. They can't reach their handler. They've tried, they've emailed, there's no responses. And nothing has changed in respect of that. So attorneys or not, the genesis is the administration of the fund, and ultimately I think that's the end of it. And that's what will ultimately give us, or give the claimants, some reprieve, is if that administration and that system considers all these things we're mentioning here, considers that we can't spend 100,000 before we lodge a claim, and find a mechanism in between the fund not having to incur these legal expenses, because after 120 days we will issue summons. Either they would have to take these claimants to experts very quickly in the time that they have. But the answer is within how the administration turns around, how it administers as opposed to blocking these claims and blocking administering the claims, because that's what we're dealing with now. Now, yes, sir, we will go to court on things, ma'am. We will go to court on these issues if need be. However, it's much better. It's much better if we lower our fences and our guards, Mr. Letswalo, and between us and you, and considering the regulations and considering the law that's applicable, find a way which will not be so burdensome on the claimant. Thank you, ma'am.
Okay, I'm going to give you an opportunity now, Mr. Letswalo. So with the scarf and then you in the red, yes, okay, perfect. I encourage you to keep it short, please, because we still have some online questions to get through too.
No, thank you very much. I'm from the BLA. I'm the chairperson of the BLA in Gauteng. My leader, Maboku Mangena, has spoken at length about the kind of problems that we have. Mr. Tian Jube also spoke eloquently about the kind of problems that we have. But I think the issue that we have here is symptomatic of a greater problem that we have in society. We have a concern that Mr. Letswalo's doors are not open. We come here precisely because the doors were completely shut. This spectacle in the media is not a good picture that we are presenting to the public. These are issues that have to be spoken about behind closed doors. Now, I want to touch on 3 issues, if I may. The first issue is to restate the legal position. The legal position is, of course, that claimants can approach the RAF directly without the assistance of attorneys. But unfortunately, what happens invariably is that claimants who approach the RAF are undersettled. That's why it's important to have attorneys, people who are properly trained, to assist them. Now, that is why, and this has to be made very, very clearly, that is why you have the kind of opposition that you are seeing from Mr. Letswalo. That attorneys come into the picture to assist claimants, to ensure that the claimants get what is due to them. Now, the picture is distorted somehow because Mr. Letswalo would want us to believe that attorneys are just in there to get money, and that is not correct. The second issue that we have to to put forth is the following. If you go to the High Court, on a daily basis, you'd see that there are matters that go on the default court roll. The RAF is simply not there. And that's a problem. Because here we're talking about taxpayers' money. The RAF is simply not there. And we're talking about Mr. Letswalo's RAF. We're not talking about the RAF that existed 10 or 11 years ago. So that is the kind of problem that we are dealing with here. That, Mr. Letswalo, let's lower our guards. Let's lower all the arms and talk about how we would find a long-term, long-standing solution to this problem. The third issue that I need to talk about, Ntate Letswalo, is your insistence that attorneys would lodge empty claims. I mean, that is ludicrous. That is ludicrous. When attorneys lodge fraudulent claims or claims that are empty, the RAF knows what to do. Right? You can't just leave it at that. You can object to that kind of a claim. So the long and short of what we seek to arrive at here is a situation where we can dialogue with the RAF behind closed doors and find a proper solution. The claimant is at the center of the kind of solution that has to be found. Speaking for the BLA, as Ntate Maboku has done, we represent the majority of members who practice in this space. And by extension, these people represent the poorest of the poor in this country. They have a piece of legislation that protects them. That is the legislation that we use as an instrument to protect the claimants. And Mr. Letswalo certainly has to come to the party. If he doesn't come to the party, then there surely has to be consequences. Because here we are not concerned about egos, but we are concerned, as all my colleagues have said, we are concerned about members of the public. Invariably, people who are victims of road accidents are people who are found in the most impoverished of conditions. So let's leave egos aside. Let's find a long-standing solution. Thank you. I know we are pressed for time. I'm grateful for the time.
Okay, so before we take some online questions, we have one more person speaking here. Then I'm going to just run through a couple of the online questions, and then we'll give everyone at the table a chance to just make some closing remarks.
Thank you. I'm not going to be long. I think the fact that we've gathered here today is because there is something wrong. There's no doubt about it. And with the greatest of respect and without hubris, Mr. Letswalo, I think the legal profession, and in particular the persons that are in here today, they are specialists in personal injury matters. They know about the law, the regulations, including the case that you've mentioned, and I don't think they need to be lectured about that. We're not here to be lectured. But what I think you, as the accounting officer of the Road Accident Fund, is to tell us whether what we have seen 6 weeks ago will not be repeated. When lawyers were told to queue on a Sunday night, slept at semi-marks, the following morning, Monday, your management came, they wouldn't assist them, they led them to turn back. I mean, that is very serious, in particular relating to victims of road accidents. And I hope that you'll tell us that it don't happen, or
What is it that we must do together to make sure that it should not repeat itself? We're not here to point fingers at you. We're here to find a solution to road accident fund. The other concerning thing is this, and I think you'd agree with me. I don't think the road accident fund should allow a situation whereby on a daily basis there are default judgments in court. I am told that in Johannesburg alone there are about 240 matters on a daily basis. Now, if you take all courts in South Africa, which are more than 12, the High Court, I don't even mention the regional courts, one cannot exclude the fact that you've got no less than about 2,000 cases that are not defended. That is a cost to the fiscus. That is why we are here, because how does the fiscus get money? They tax us. So the request also is, we know, and the judiciary has come to the party. 2 years ago, you went to court and asked the court to give you an indulgence that, and it was good for you to have done that, I must say. I must credit you on that one. That the judiciary, can you please allow me, and you consider that the financial position, there's a mess at the RAF, the financial position at the RAF is such that I don't know the age analysis of the creditors. So allow me to pay the oldest debt first. So I would like to hear you to tell us whether the 180 days that you've requested, you now have got less than that, or you don't have any creditor that you owe for more than a year or two. I've got other things to say, but I'm told that I must, I should stop. Thank you.
Thank you so much. I think I'm audible enough. I can pick up the mic from here. So those that are watching online, they are able to hear me. But it's quickly, because on the YouTube, it's mostly comments than questions. So I'll read one question from Zelda Fenter from Pretoria News or Independent Media. This question goes to the RAF CEO. What does the fund say about Scopus recently labeling RAF a national disaster? And I think it is as brief as that. Most of the, on YouTube, it's mostly comments. So I don't hear the question.
Okay, so what I'll do is I'll invite Mr. Letswalo to answer to that question, and then also provide some closing remarks and potential solutions. And then I'll also give our representatives here, if they want, an opportunity to just provide some conclusions. We have about 10 minutes left, so I'll be very strict with the timing.
No, thanks very much. Moha, I think you are economical with the truth. You must tell people you are the lawyer. So don't just say I assist people. Say I'm an attorney. And if you are, but I mean, the reality is that you speak for the attorney, so you must say that. Look, I have no ego to bruise. My ego has bruised so many times arrived. And the task at hand was to save this sinking ship that was already underwater. So it was a Titanic facing an iceberg. We were not going to move around the deck chairs with a view that it won't crash. So that's what we were doing. And that's what we are doing currently. Let me start with the part where, you see, Zelda Fender is going to have to answer a question that I have also for her. One of that is that, why did she receive the judgment from Mpumalanga High Court with all of us at the same time and not other journalists? I think she must answer that one. It's a very interesting phenomenon, and we're going to have to deal with it. We are coming there. The issue around SCOPA, I'm not going to talk about SCOPA because I don't know what is the objective test they used. I mean, if you arrive in a place where Section 24 of the Act says you must receive paper, and you guys know you deliver truckloads of paper, where should it? I don't know where the objective test is from SCOPA to say this thing is a car wreck and all those things. And I think we've got our own issues that we'll deal with at the intergovernmental relations with SCOPA. I don't want to, they are an important element. We report on what we do on a daily basis or things that we do quarterly to the Portfolio Committee on Transport. SCOPA is for public accounts, so they actually deal with matters of financials, of things that have happened in the past. So continuously we deal with the Portfolio Committee on Transport on those matters. And that Portfolio Committee actually knows where RAF comes from, where we got it. There is a, let me dispel the myth that these legal representatives that we had on our panel were the best people. Because here's Section 34, Rule 34 of this Bertelsmann judgment. I like it, this judgment. The legal representatives, the fund's legal representatives were complicit in operating this scam, as were those of the plaintiff. So you can understand. I don't want to get more into the details. No. There's nothing isolated about it. We'll explain. We'll explain that part. And I think you must let me finish because I allowed you to talk. So please, let's keep this in the way that it should be, which is in a professional setup. They readily considered that they should never have agreed to pay the plaintiffs' cost at high court scale. This is the very same people. By the way, let me tell you what used to happen. So in the RAF, when direct claims used to get to a point where they prescribe in the hands of the funds, the fund will actually get to the same panel and say, issue a summon against me. I mean, this is a very strange phenomenon, and they agreed with it. So the thinking that there won't be an empty claim, when, as we speak now, 97% of all the claims you submit are not compliant, is a very strange one. In the backlog, we had 90% of all claims, majority of them from lawyers, also not compliant. So there's no story about the fact that now that we brought this thing and a minimum requirement. So you can't have both. You can't have a situation where you want us to settle claims quickly in the interest of the claimant and give us incomplete documents at the same time. So it must be that it's a social security mechanism. And the difficulty with it is that it's based on delict. It shouldn't. And that's what RAPS was trying to do, which you as a fraternity also fought. Okay? So that's also a fact. So there is a phrase that was used. This is Mr. Letsoalo's RAF. I have no RAF. I have no RAF. I'm hired here. And contrary to popular belief, I competed with lawyers. And I actually became successful, and they were unsuccessful, as it were. All of us went there, presented our views. So the argument that, no, this person must be a lawyer, is because you couldn't find a lawyer that beat me in that interview. So there's no process on that. So there can't be issues around that. So the part where people want to they are trying. That's what I'm saying is confabulations. I don't want to say people are lying. I think they are generating false memories about events, because here is the actual reality. We had 10.6 billion that was being paid to the legal fraternity. We don't have that now, and that's a fact. Okay, we had a situation, people, and that's what I'm saying. Even the memo is based on hearsay. They say there were 100 or more. It was actually 86. Go check with your do your own research, because you are saying direct claims at the RAF. There is no person who's busy there saying bring claims. Yes, we encourage people to come, and when they come, we tell them, look, 19C says this provision. It's 19C, it's the law, it's not us. Because our predecessors thought they can do this and all that. And there's this thing of under-settlement, over-settlement and all those things. They're thinking, people say, no, if it's not compliant, the lawyer won't bring it. Why are we having 97%? Why did we have the 90%? It's not true, okay? Let's talk about facts. And that's what I'm saying. All these things are said without the hard facts. Now, when a judge is dealing with a fraudulent claim, he doesn't know it's fraudulent. He doesn't. Until we go investigate this claim. And the reason why the information won't come is because most of them are also fraudulent. Okay? You get a situation where there is a person who got injured. We had 2 buses colliding in Eastern Cape with the driver and the assistant in those 2 buses empty, still going to a rally to fetch people. We had more than 200 claims coming out of that. And we want to be told that this is the minority. I don't say it's not the minority. I don't have any hard evidence. But what I can assure you is you do nothing with them. 102 law firms who have reported. We said they took more than R1 billion of duplicate payments. We report these 102 law firms. You have done nothing as the legal fraternity. Nothing. We are saying it today. One of them last week was being caught to say 25 million was being mismanaged in the trust account. One of the 102. And we continue, right? This story of saying we go to court, that's fine. That's why you are here today, because we can't lecture the legal fraternity about the law. We won't win. We win all the time, in fact. Because what has happened, when we win, you don't say it. My own appointment was challenged until the Constitutional Court. You lost, now you are coming to the minister to say, and when you state these things, you don't say, here is section 12(1)(b) that says who it must be, the CEO of RAF. There's no way where it says a lawyer, and you know that, then you don't mention it, and then you mention other things. It was a conglomeration of all of these issues. We are saying, there's a part where it says the door is shut in our face. We met you in December. Show me where you said you want to meet. In fact, when we issued out this tender, which is the RFP, and people wanted, there was a point at which the BLA called me. And they said, no, there is a session where people must have a compulsory briefing session. People can't get in. We then brought another one, because the BLA said to us, people could not get in. It is the very same BLA that says today our doors are shut. But they have got a number where they can call me. They know where I am. My numbers are very clear. 082-6733-009. That thing is a call center. You just call there, I answer. So there's no story about us hiding ourselves and all that thing. We do not want to go in private and discuss these things in private. Because you brought them to you wrote an open letter and you are saying, let's talk in private. You should have written a private letter, we'll go in there. I still believe very strongly that if we are working in the interest of the claimant, you would agree that the submission of documents is important. And that's why you have got contingency fee agreements, isn't it? That you must take the risk of submitting this claim, knowing very well that should you be successful, then you get your 25% or your fees, whichever is lower. Thank you.
Thank you very much. I'm going to give a last opportunity. Maybe you can speak on behalf of your colleagues, just in the interest of time. So,
I can do that. Thank you very much. Mr. Zolo, when a Titanic is facing or is approaching an iceberg, and the rescuers do not know what is happening in the ship, they know that there is a captain and assistants to the captain. You do not start by taking out the assistance to the captain, because you may soon find that the captain is not there. So we have written a letter reaching out, asking for you to avail yourself so that we can together share in finding a solution to the problems that we have. The mudslinging that you would want to engage us in, it's really not necessary. We remain committed to meeting with you and your management, and we look forward to receiving a response to the letter that we have sent to you. Even if your response is public, we are fine with that. We are fine with that, but we would want to see a commitment on your part, on the part of your management, on the part of the leadership of the country, including the Minister of Transport and and her deputy, committing themselves to finding a solution to this problem that we are facing. You see, this is the only country that we have. We can't go to Canada, we can't go to Australia. If we've got a problem, this problem must be solved by no one else but ourselves. And up until we arrive at a point where we all agree that that which is happening at the fund is a crisis, it's a catastrophe, it's a calamity, we would never have the necessary resolve to deal with it. So a crisis calls for a particular attention, and we are availing ourselves and our resources to find a solution to this problem. And we would want to thank you for availing yourself to this press conference, although we were not looking forward to seeing you, but we appreciate that you came.
One of my greatest disappointments as a litigation attorney sometimes is having spent a lot of time in preparation for the ultimate concluding argument to be diluted to personalities and almost turned into a bit of a joke. I stand here very disappointed that attorneys could take the time and effort to prepare substantively what they have in terms of submissions regarding the crisis at the Road Accident Fund, which is by no means a new occurrence. It's been going on for the longest of time. And ultimately, Mr. Letswalo, to hear that the sum total, if I summarize it, is generally two things. A defense of the position of where the Road Accident Fund finds itself with no solution. I mean, there's not a single solution that has been suggested by you, sir. And secondly, that the argument or the discussion or the debate or conversation centers around you as a person. So now we're having a conversation around you, your credentials, which I don't find appropriate at this point to even have had a listen to. What am I saying? I'm saying that what is really the sum total, and then I'm done. What is really the sum total of why we gathered here? I drove from the south of Johannesburg to ask myself, standing here, what did we actually achieve in terms of constructive dialogue? And all I'm still hearing is that we are belligerent, standing one on the one side and one on the other side, with our gloves ready to face each other and to bring up all historic battles that have existed between us, but no solution. I think it's time for us, one of our panelists said, for us to lower our guards, honestly, and let's start working together. Otherwise, we are going to stand at this position a year from now and be worse off. And the sufferer at the end of all of this are the victims.
Okay, ladies and gentlemen, we have run out of time, so I'd like to thank you all for being here today. This room isn't necessarily going anywhere, so feel free to discuss amongst yourselves and so on, but I have to run to another meeting. So thank you very much for taking part. I really appreciate everyone staying calm and collected. So we'll see you at our next briefing. Have a lovely day. Oh, okay.